for joining us for the keynote address of the 14th Annual Investment Treaty Arbitration Conference. Whether you're joining us for the first time today or you've attended the earlier conference sessions, we welcome you today. I would like to introduce our moderator for the keynote address, Frédéric Sourgens. Freddy is a globally recognized authority on the intersection between international energy law, international dispute resolution, and transnational law of globalization. His publications include a dozen books and over 50 articles, essays, and book chapters. He is currently a professor of law teaching at Washburn University in Kansas. Freddy was also a panelist on our last session, that would be session 4 of the conference, which is available via recording. If you missed that session, you can get in contact with Juris at marketing@jurispub.com, and we'll get you that recording, as well as the recordings of the previous 3 other sessions. Immediately after this session, we will be hosting a separate after-hours meeting where further discussion and audience questions can be presented. A link will be posted in this session's chat, and it will also be emailed to all audience members for anyone who is interested in joining. It is not mandatory, but we would love to see you there. Lucinda will be there, and we'd love to see your face and hear from you. And with that, I'm going to turn it over to our moderator, Freddy. Freddy, thank you.
Thank you so much, David. It is such a privilege to be here with you today, and I am really looking forward to today's keynote address by Lucinda Low. Lucinda is a partner at Steptoe & Johnson in Washington, D.C., and is truly one of the giants of international and transnational law in the United States. It would be a very long time to go through all her accolades, so I will try to be brief. The first thing I would like to note for you is that Lucinda is not just an expert in dispute resolution and international arbitration, but in fact has significant experience in FCPA anti-corruption, in World Bank and IFI investigations, anti-money laundering, and business and human rights, which are all aspects that significantly impact investor-state dispute resolution. She is the member of the board of directors of Coalition for Integrity, which was formerly known as Transparency International USA. She sits on the Secretary of State's Advisory Committee on International Law, is the former president of the American Society of International Law, former chair of the ABA section of international law, and the 2003 recipient of the William Ray Valance Award presented by the Inter-American Bar Foundation, presented to an individual who has made a significant contribution towards improving the law and jurisprudence of the Western Hemisphere. Of interest to the current crowd, I would assume, is that she is also a member of the panel and president of arbitral tribunals in 5 pending ICSID cases, which include Sociedad Aeroportuaria Conturvasi versus Peru, Joachim Bernard Buse versus Panama, Unicredit Bank Austria AG versus Croatia, Hydro SRL versus Albania, and participated in the concluded case in Capital Financial Holdings Luxembourg versus Cameroon. What I really look forward to is also the topic of today's talk, which is very timely and links with the discussions that we've had so far in the conference. The topic and the title of today's talk is the difference between evolution and revolution in trade and investment dispute settlement mechanisms of chaos, crossroads, and the R factor. Lucinda, I greatly look forward to your talk.
Thank you so much, Freddie, for that very kind introduction. And thanks to David and Todd Weiler and the whole JURIS staff for this opportunity. I've really enjoyed all the panels that this conference has featured, and I congratulate the speakers and the commentators on their papers and the discussions. I'd also like to thank my associate Chloe Baldwin for her contributions to what I'm about to say. You just heard the title of my talk from Freddie, the difference between evolution and revolution in trade and investment dispute settlement mechanisms of chaos, crossroads, and the R factor. So what is the R factor, you may ask? Well, it will be revealed as the talk progresses. But for now, the true or false question is, will revolution alone be required to remedy the perceived problems of ISDS? I will not answer that in a short fashion. My remarks are really intended to build on some of the prior panels while looking a little more broadly at the topic of international economic dispute resolution, encompassing trade as well as investment, for some comparative insights. So let me start with a few statistics. WTO and investor state arbitration are the two busiest international dispute resolution mechanisms in the world. In its 25 years of existence, the WTO has concluded close to 600 cases, while the number of publicly known investment cases has reached over 1,000. By way of contrast, the International Criminal Court has dealt with only 27 cases in its briefer history. The International Tribunal for the Law of the Sea has dealt with 29 cases, and the International Court of Justice has entered 178 cases on its general list. Moreover, the economic dispute settlement systems have been in greater demand than ever in recent years. For example, the number of disputes filed in the past 10 years have increased in both the WTO and under investment treaties. In 2018, the number of panels established to hear disputes in the WTO was at an all-time high at just under 30 cases a year compared to 10 in 2010. In 2018, treaty-based investor state disputes reached an annual number of 71 cases as compared to just over 10 in 2010. Moreover, more states are actively involved in economic disputes than ever. The WTO reports that 109 member states have actively participated in dispute settlement as a party or a third party. And the 71 investor state cases that I referred to earlier in the ISDS system were initiated against 41 different countries, with 3 states, Belarus, Qatar, and Rwanda, facing their first known investor state claims ever. Yet despite the obvious demand, the current climate of international economic law has been described as one of chaos, and cries to dismantle the system and start afresh from both the right and the left have been rampant. These claims have been applied to both ISDS mechanisms and to the WTO appellate body, which was formerly referred to as the jewel in the crown of the international trading system, but as most of us know, is now in limbo. So this year's JURIS Conference has revolved around questions of systemic reform and whether it is true or false that particular reform topics should be mandated or at least taken up. But the broader question, in my view, that we must confront is whether the economic dispute settlement systems are really in chaos, and if so, what is to be done about them and by whom? And it's in the latter that the mysterious R factor comes up. So let me start just by talking about a few of the criticisms that have been levied against these systems of dispute settlement, because it bears on the question, are we really in a state of chaos? There's been, in the ISDS side of things, many who've argued that the system lacks legitimacy. The criticisms here are pretty well known, I think, especially to this audience, although the critics themselves don't always agree with each other and debated. But they include, for example, criticisms of excessive cost and duration of proceedings, lack of consistency and coherence in the interpretation of legal issues, insufficient transparency, subversion of democratic values, insufficient scope for legitimate state public policy or other interests, preferential treatment of foreign over domestic investors, and a lack of asserted diversity, independence, impartiality, and neutrality of arbitrators, and conflicts arising from multiple roles, such as dual hatting. And as regional movements have emerged, we all know that further criticisms have come to the fore, probably most prominently reflected in the 2018 decision of the European Court of Justice in the ACMEA case, and the subsequent agreement of EU member states to terminate their intra-EU bilateral investment treaties. Likewise, the WTO dispute settlement system has been at the forefront of controversy. The United States has been a particular critic, although it's not been alone. But you can see many of these criticisms in a 175-page report issued by the U.S. Trade Representative earlier this year that highlighted a number of things, allegedly that the appellate body rulings overstepped their bounds by reaching decisions that go beyond the text of the WTO agreements, that the appellate body members issue rulings that elevate the significance of past decisions to near binding precedent in a way that was never envisioned or agreed upon by states, excessive duration of cases, and a failure to meet the timeline specified in the rules. But all these pale before the blocking of appellate body appointments by the United States, which culminated in December 2019 in there being an insufficient number of members of that body to hear appeals. Really an existential threat to the organization, and it's led to the demise of the central way in which trade disputes have been resolved for over 20 years. Now, without overstating it, there are, in fact, as I see it, some common threads of concern between both the ISDS and the WTO systems. Let me talk first about concerns over excessive costs and duration. There was on costs. There was a 2018 study by Jeffrey Commission, I think one of last week's panelists, and Rahim Malou, that concluded that in ICSID arbitrations, the median cost for each party is around $3.5 million. The WTO side, really, we don't know what those costs are, largely because there's no mechanism for awarding costs, and the states don't publish those figures. But it's clear that the issue of excessive costs in international dispute resolution is inevitably linked to the length of the proceedings, and the longer the duration, the higher the costs. And in that respect, statistics show that the duration of proceedings in the economic dispute settlement sphere is more or less the same. The average duration of ISDS proceedings is 3 to 4 years. I'm leaving aside annulment with that statistic. But that's only slightly longer than the recent WTO disputes, including an appeal phase. Second, and directly related to the first concern, long and unwieldy decisions by arbitrators or panelists have been criticized as being unnecessary and adding to the cost and duration of proceedings. Now, in the WTO, panel decisions can reach a breathtaking over 1,000 pages, with panelists seeking to exhaust every issue raised in order to avoid being reversed on appeal. In ISDS, there can also be concerns, for example, about annulment for a failure to state reasons that may create incentives for tribunals to address issues more exhaustively than is necessary for a decision. Third, concerns have been raised in both economic dispute resolution fora with respect to issues of legal interpretation. But here, I would say there's divergence between the concerns that have been expressed. With respect to the WTO dispute system, critics have claimed that precedent actually plays too great of a role in ways never anticipated by the drafters of the dispute settlement understanding and WTO agreements. In the ISDS system, in contrast, the claims are that the ad hoc nature of tribunals has led to a lack of consistency and coherence. Now, notwithstanding this divergence in critique, both have been argued to be the cause of some chaos within their respective systems. So that's worth thinking about a little bit. Fourth, criticisms have been leveled at the decision makers in these institutions themselves. In the WTO, critics have argued that the Secretariat has a far greater role in developing decisions than it should, and that decisions of both panels and the appellate body overstepped their mandate. In the investor state system, on the other hand, the concerns about lack of an independence and impartiality of tribunal members are the ones that have expressed. And this has been a significant enough issue that the institutions concerned have developed guidelines and increasingly tighter rules to combat these perceptions. Finally, in the litany of comparative critiques, both trade and investment disputes have increasingly faced barriers to negotiated resolutions. On the WTO side, the rise of economic nationalism has stymied more informal consultation processes between states and has made it almost just a formality before the initiation of a formal dispute. On the investor state side, there is not only often limited consultation before a dispute is formalized, but many countries are reluctant to enter into negotiated resolutions, including forms of ADR, such as conciliation or mediation, for fear of appearing weak, or particularly for officials of developing nations, for fear of being accused of having been bribed or improperly induced to settle. And that's a concern that's very personal and very real. These criticisms have seemingly reached the boiling point in both spheres. But are these descriptions of chaotic systems facing demise accurate, or are they more symptomatic of an evolution in the global world order, including the international economic landscape? There's no question that globalization has increasingly led to larger markets, increased investments, increased trading of goods and services, increasingly complex supply chain, and as a corollary, increased litigation. And within countries and between countries, there is greater complexity in economics, political, and social phenomena that can lead to disputes in the trade space, in the investment space, or sometimes crossing over between the two. But perhaps the economic dispute settlement systems could be better described as being at a crossroads rather than being in chaos and requiring revolution. There are important decisions and improvements to be made, including to address concerns that have come to the fore as these systems have increased in prominence and use, but query whether this requires a definitive tearing down of the system. I think not. And the less radical approach also seems to be the clear preference of many states, which have actively engaged in reform proposals in an effort to remedy perceived weaknesses in the systems. With respect to the WTO, for example, the vast majority of states have been actively participating in dispute settlement body meetings and collaborating on proposals for reform. And you even have very recently a subgroup of members, including the European Union, who've agreed on an interim appeal mechanism, recognizing that it's an essential feature of the rules-based trading system. In the ISDS world, of course, this group is very familiar with some of the reform efforts that have been going on, and I won't spend a lot of time on them. We have the UNCITRAL Working Group 3 process. We have the ICSID Rules Amendment process, and these aren't just tweaking the system at the margin. They're really significantly rethinking some of the system's core process issues based on extensive consultations to try to address some of the problems. And of course, we've had the move, especially by the EU, to negotiate multilateral investment courts as an alternative to ISDS. So to me, this reflects a commitment of states to improve the investor state system and the WTO system rather than tear it down. So we're really seeing a period of evolution and adaptation by states rather than revolution and a wholesale revamping of systems in chaos. And now we come to the R factor. We started with a true or false question, whether there was only one R word, revolution, that would remedy the problems of the WTO and ISDS systems. But as we have seen, R has moved towards reform, but reform will only work, in my view, when it's combined with the other R words of reflection and responsibility. Well, what do I mean by that? Even if the system is not crumbling, it's provided some valuable lessons for reflection that can lead to reform. And indeed, all systems have to change and evolve to meet changing circumstances, including perceptions of legitimacy. A rules-based framework for the settlement of international disputes really is foundational and, in my view, vital for the long-term success of any reform system. And as we've seen, these disputes continue to grow in number and complexity. So it really becomes imperative that these dispute mechanisms, dispute settlement mechanisms, continue to evolve in a way that can serve the important legal functions of stability, predictability among states and private actors, as well as legitimacy. Now, in my view, this framework can really only be settled and strengthened with the participation and support of all parties. And this is where responsibility starts to come in. And it requires all actors in the system to play their part. States have to actively engage and listen to each other in order to establish a system that's sustainable and addresses the diverse concerns of all members. Our WTO experience has made it pretty clear that unanimous consent for the regulation of systems, at least like the WTO, is difficult, if not impossible. You need flexibility to be sustainable. Besides states, institutions and their leadership likewise play a key role in reforming the systems. Institutions are creations of state, but they're central repositories of knowledge and experience. And with proper leadership, they have the power and the ability to either help or hinder the development of dispute resolution fora. Finally, there's everybody else, all actors in the dispute resolution systems for economic issues, including private investors, their counsel, the arbitrators themselves must do their parts. Investors who are the beneficiaries of the system frankly put it at risk if they engage in conduct that may be self-serving in the immediate term, but ultimately undermines the necessary support for the system. Decision makers have to take measures that will cause them to be viewed as legitimate and qualified and properly vetted to carry out their important functions. So to me, these lessons can and must guide the evolution of the system. With this background in mind, I'm going to focus my last few minutes in particular on investor state issues and offer some suggestions for continued consideration as we work to evolve the investor state system. Now, I'm not going to touch on every issue that's out there. We'd be here all afternoon and into the evening, but I'd like to highlight 6 areas for further consideration in this process and put forward some ideas for later discussion and development. First, in the short to medium term, states can make greater use of existing provisions that allow for non-disputing treaty party submissions on questions of treaty interpretation, as well as binding joint interpretations of treaty provisions. This has worked reasonably well in the context of the NAFTA, in my experience, and can help to enhance the coherence of legal interpretations and to prevent perceived overreach of tribunals in ways that states may never have contemplated when they negotiated these provisions in the first instance. A caveat here, states should not succumb to the temptation to use these mechanisms to rewrite the history of their negotiations or to prevent disputes arising under the scope of the treaty as originally agreed just because their defensive interests are now invoked. This is a tool that is available relatively immediately in some instances. Second, transparency. States should ratify and utilize the Mauritius Convention and other transparency provisions to enhance the coherence, legitimacy, and predictability of the system. As of today, only 23 states have signed the convention, and of these, only 5 have ratified it. There have also been other attempts in UNCITRAL and ICSID to improve upon the transparency of the system, which are commendable, but they haven't received the uptake from both the investors and the states that will make them as effective as they could be. And I'll hold off on the detail of this, but the mechanisms are there if the parties will take them up. Now, I recognize in saying this that there are going to be important confidentiality interests that come to bear in ISDS disputes, both on the state side and on the investor side, whether it's essential state interests, business confidentiality, personal privacy, but at least in my experience, it's usually possible to address these particular issues and still negotiate and navigate a transparent dispute resolution process with things like redactions and whatnot. And in the face of claims that the system lacks coherence and legitimacy, especially in democratic states, I think both states and investors really have to consider committing to greater cooperation and transparency in the conduct of these disputes. So that's number 2. Number 3, as part of the longer term issues to be addressed, I would suggest that both states and investors need to participate more actively in settlement negotiations, and reforms should seek to incentivize settlement mechanisms, or at the very least, mechanisms to narrow the issues that are in dispute. Of course, there are going to be circumstances where settlement discussions are not going to be fruitful, where the parties are just too far apart to reach a negotiating resolution. But in many cases, even partial approaches may have increased the efficiency and cost of the dispute resolution process. For example, parties could enter into a compromis for purposes of the dispute to try to narrow the issues to be resolved and therefore limit the scope of submissions and costs. Well, you might say, well, they could do this today, but I think these kinds of approaches could be more encouraged and utilized. Parties could, for instance, be required to provide a joint list of substantive issues to be determined by a tribunal as part of the preliminary procedure of a case. Alternative methods of dispute resolution, such as conciliation and mediation, also need to be encouraged. The ICSID conciliation mechanism is severely underutilized. I know this since I've been on the roster since the U.S. appointed me in 2016, and I'm only doing arbitration cases. We have the Singapore Convention on Mediation, which is going to enter into force later this year, and some have said that has application in the ISDS arena. I don't fully understand that yet. It seems like it's really geared toward commercial disputes, but the success that it's had should cause us at least to think about what more we can be doing in the ISDS arena specifically to try to encourage the negotiated resolution of disputes. Fourth, and somewhat related, institutions, states, and disputing parties can take greater responsibility to further develop and actively utilize consolidation and coordination provisions under the applicable arbitration rules. While procedural mechanisms do exist in practice to address concerns about related or substantially similar claims, and there are provisions for multi-party claims and the grouping of ancillary claims, further work is really needed, in my view, in this area. This is something that could greatly improve efficiency and costs of proceedings, particularly where there are important common facts or common legal arguments, particularly arguments that could be dispositive of an issue or a defense. And the benefits of a more consolidated hearing of these issues would also mitigate the risk of inconsistent or contradictory awards, avoid parallel procedures, and put before whoever the decision makers are the most robust accounting of the facts on which they could make their decisions. Consolidation may be particularly appropriate for cases that are linked to economic phenomena that affect a particular country. One thinks, for example, of the 2001 economic crisis in Argentina, which led to over 40 cases, or phenomena that affect a sector, such as the energy reforms and measures taken by Spain starting in 2010 that have resulted in at least 41 separate cases to date. These are the biggest examples, but there are other smaller examples as well. But states and institutions really need to take a hard look at their consolidation mechanisms. Why has the consolidation provision of NAFTA, for example, been underutilized? Well, having successfully fought off a consolidation effort in the high fructose corn syrup cases against Mexico, I can say that my own view is that the NAFTA provisions have too low a threshold and are really too blunt an instrument. It may, rather than an all or nothing approach and a forced approach, it may only make sense for consolidation to occur around a limited set of issues where the common factors outweigh the individual ones. And so it seems to me this is really an area where variety and flexibility in the available tools is going to be key to success. We also may need to think about referral mechanisms for particular issues, something we see in other parts of international law, but not really in this arena. So this is all part of creating mechanisms to help narrow core issues and present them in the most efficient manner. Fifth, as states continue to negotiate multilateral free trade agreements with investment chapters or bilateral treaties, or to review their existing treaties, it really is incumbent on them to reflect on past experience and start to incorporate incremental shifts or clarifications that reflect evolution of jurisprudence and practice. Whether this goes to foundational definitions, the scope of particular protections, a carve out or specific threshold requirements for particular kinds of disputes or others, these kinds of things could improve the treaties, could clarify the scope of their intended operation, and perhaps preclude some disputes that have been protracted about for example, whether there's power to retrospectively tax as a sovereign right, as in the case of Vodafone v. India, or whether the right to regulate against tobacco advertising falls within the police powers of the state. Sixth, and finally, at least for today, if we are to go the route of creating a multilateral investment court, we need to really reflect on the lessons learned from the WTO appellate body. It's argued that such a court would make the dispute settlement process more accountable, that it would develop a coherent body of principles and interpretations that would ensure predictability and legitimacy. There had been suggestions at the outset of this discussion that the WTO appellate body really provided a blueprint for the creation of an investment appellate court. This, of course, seems to us highly ironic. today, given what's happened to the appellate body. Now, that doesn't mean that there aren't lessons to be learned, and there may be even things that the appellate body has done well that should be replicated. But it really highlights the difficulty of implementing a multilateral appellate court mechanism that balances the needs of all participants. And I would just note that, you know, the mechanisms for the resolution of ISDS disputes really are significantly more complex than you have in the WTO. We don't have a single regime in ISDS. The affected parties include both private and state actors. And as others have pointed out, you've really got to balance the purported benefits of stability and coherency that you might get from an investment court with other criticisms of ISDS, including diversity and quality in the decision-making pool and the cost and duration of ISDS proceedings, which are only going to be increased if there's a second tier of review. So I'm not going to take more time on this today. We could discuss it for a long time, but what seems clear is that a standing appellate body is not a panacea to the issues identified for reform, and we do need to learn from the more recent lessons of the appellate body. So just to conclude, and then I'll turn it back to Freddy, rising nationalism and a fragmented world means strength in the rule of law is more vital than ever. As international economic dispute settlement systems face these unprecedented challenges, I hope this review has shown you that even though we have doomsday cries of critics that these systems are irretrievably broken, what recent events have shown us is that there is much more than a revolution commitment, a commitment by states to work together to improve the mechanisms currently in place. So we are at a crossroads rather than in chaos. And continuing with this commitment to reform is the only way forward. The system can evolve not by seeking to go elsewhere, but by paying attention to and embracing on its experiences and lessons learned. So I will leave you with the thought that it's incumbent on all players in the dispute settlement system involving investors and states to consider the R factor going forward in lieu of revolution, reflection, reform, and responsibility. Thank you for your attention. Back to you, Freddy.
Thank you so much. That was a truly inspiring keynote address for a jurist that was dealing with different panels looking at each of these items in turn to sort of zoom us back out and look at the whole picture. And before I get started with an icebreaker question of sorts, I just want to remind our attendees that at the bottom of your Zoom screen, you see two features. One of these features is the chat feature, and one of these features is the Q&A feature. So if you have a question that you would like to ask, please use those two features, and I will try to get through the questions as much as I can, and to the extent we run out of time, I might select a few. So while I ask the first question, please feel free to use those two features to get in touch with our panel. So the first question that came to mind when you spoke about the crossroads that we're at between reform and revolution is, what is the virtue of investor-state dispute settlement that we would lose to the extent that we would go into a revolutionary mode and scrap the entirety of the system?
Freddy, it's a great question, and it's one I had started reflecting on earlier this year for another panel I was part of, and that the ASIL had organized, and I think the organizers thought that the panelists would be hard pressed to come up with benefits, and they ended up being surprised. My answer would be that, and it sort of picks up on what I was just saying about the multilateral investment court. I think there is a lot of diversity in the investment law system and investment law treaties. Some might say too much, but these are creatures of state will. after all. And so I think one of the main benefits of the current system is its diversity, is its potential for diversity. And I mean that in various dimensions. Obviously, we don't have enough of certain kinds of diversity. I think that's well established. But I mean, diversity in experience, approach, ability to apply the different principles that may come up in treaties, and the flexibility to establish a panel that fits the needs of the case. So the system still is grounded on choice and consent. And I think that diversity in the broader sense is a really important element to preserve in a system that has those foundations. So that would be my fundamental response to your question.
We could probably go on all day for Monty Python fans to go, what has Rome ever done for us, right? Let me turn to one of the questions that we had in the Q&A. Jennifer Thornton had an excellent question, and she wonders whether you could expand on your comments about encouraging increased use of consolidation mechanisms. Specifically, would you recommend that the NAFTA provision, which is often the template for those mechanisms, be revised in a particular way? And do you believe that referral mechanisms might work in this context?
Well, so those are two different questions. Thank you, Jennifer. Jennifer was on that ASIL panel with me and had some great comments, in fact. Regarding NAFTA Article 1126, the answer is yes, I would revise it. NAFTA 1126 permits a consolidation request to be made when one or more than one case has a common question of fact or law. And then there's a whole mechanism for establishment of a consolidation tribunal, and that consolidation tribunal is the body that ultimately decides on grounds of fairness and efficiency whether consolidation should occur. They can do partial consolidation. They don't, as I recall, have to do full consolidation. So I don't quarrel with fairness and efficiency tests. I think those are important touchstones. What I have come to think is that the threshold trigger of a common question of fact or law may be too low, in fact. It doesn't take much for these cases to have a common question of fact. It doesn't have to be a dispositive question. It doesn't have to be a core question. It just has to be a question. That's a pretty low threshold when you think about it, particularly if it's not approached on a completely voluntary basis, which is how the NAFTA is structured. Now, if you look at the ICSID rule amendment project, they have gone back and forth a little bit, but I think working paper number 4 in the current draft, contemplates that it would be purely voluntary. I'm not clear, and that would get over some of those objections. And this is going a little bit beyond your question, but it's a broader question. That would get over some of those objections, and yet it looks to me potentially as if you still might be in more of an all or nothing situation. And I think, going back to what I said in the talk, I think we really need to be creative here and give the parties maximum flexibility. The idea that you're going to go set up a whole separate consolidation tribunal and they will decide and then take the case, that's a very cumbersome mechanism. That's actually what led me to think about kind of referral ideas in this context, thinking about what can happen with the ECJ and national courts, and thinking about other international law arenas where there may be referral mechanisms. So more thought needs to be given to that concept. I don't mean to say I have fully thought it through or have all the answers, but you do look at these cases like the Argentine case and say, well, what, except for the experts who were hired in each case to opine on issues of necessity, was it really efficient? to go through that exercise, every time. And it wasn't quite every time. There was some spillover, but there've got to be ways that will help when you see these big common issues to get them resolved in a more streamlined fashion that also leaves scope for party autonomy with the rest of it. If you're getting into issues of quantum, or other factual aspects of the case, the cases may not be aligned at all. I mean, the reason the client I was working with when I was counsel, opposed consolidation so strongly in the NAFTA case I alluded to, part of it had to do with concerns about confidentiality, because the other affected companies in the industry were deep competitors, and there was a lot they didn't want to expose. Part of it had to do with they were the smallest of three behemoth companies, and they feared that as the smallest, they were going to be disfavored in this process, and there were others, but so that experience really led me to think that it can't be all or nothing. There has to be a diversity of approaches. You need to be able to tailor it to fit the situation. And if you're trying to reduce the cost and efficiency of these things, you need to find a more streamlined way. So that's kind of what went into the thinking. Long answer to your question, and I've tried to wrap in the referral a little bit as well, because I think it's tied in.
To sort of ask a follow-up to that is what happens, part of what we've seen in Argentina is that these claims keep trickling in on the common question. And so then you have the CMS annulment, in which Judge Crawford pointedly told all of us that none of us knew what we were doing. And then turns out that the cases then start changing. How could a consolidation mechanism deal with these kinds of later coming cases?
Well, yeah, and then it's not, consolidation doesn't work for those, and the ICSID rules, the proposed new rules, talk about coordination and the idea that you might have agreement for some cases to lead and others to follow, and even though there's no precedent as such in the system, I think we've seen, in an effort to bring as much coherence and to rebut the criticisms of lack of coherence and inconsistency, we've seen more effort to do that, and I suspect that will continue. I mean, I don't think you fully resolve that issue unless you have some mechanism, and this would be radical in terms of the system, for a binding ruling to be issued with respect to the issue of necessity, or whatever the core issue would be. And is there appetite for that? I don't know. Otherwise, you've got to rely on the persuasive course of who's ever set up to decide it first. And I think many arbitrators are very sensitive to those issues, because they do recognize the systemic implications, but it relies on kind of a social compact then, instead of a legal mandate that the institutions can help support. But no, these aren't easy issues, but I think they really need to be grappled with more than they have been to date.
We don't currently have any questions in the Q&A, so I get to monopolize the conversation a little bit more. And one of the things that sort of stuck out to me when you talked about point 2, transparency, that only 5 countries ratified the Mauritius Convention and only 23 signed it. I'm sort of wondering to what extent state parties may be afraid of transparency and being exposed in some of their less, appealing dealings. And that how the sausage is made gets revealed. Is there a way that one could have a transparency mechanism that would be sensitive to, while there are certain things that would lead to political problems, while at the same time also dragging states maybe a little bit against their will to be more transparent and say that, look, it's not that bad, just show your cards already.
Right. No, I'm no doubt those sensitivities exist. We would be naive not to consider that they exist and may influence the responses of states to desires for transparency. And of course, it gets complicated if there are multiple disputes, going back to the previous topic, arising from particular measures. It can be latent. So I think that's really why I said we do need, in a world that leans toward transparency, which is where the institutions are trying to take us, and where I think it is sensible to try to go from a legitimacy standpoint. There do need to be mechanisms within that for taking account of legitimate confidentiality concerns of both parties. States can certainly have, at one end of the spectrum, national security interests that obviously need to be recognized, and we won't get into the whole question of how you determine those, but there are those interests, but it's not limited, at least in my view, just to national security interests. There may be other state interests. I mean, a case may well expose, certain aspects of the deliberative process of a state, and that's going to be hard to insulate, totally. But there may be other instances where the state really can demonstrate a legitimate need for confidentiality of the information. It may only be for a limited period of time. It may not be for the, forever. It may be that it's critical for 6 months, a year, whatever the period of time is. And so in thinking about transparency, there does need to be, I think, some accepted grounds for that. And it's not just on the investor side, it's absolutely on the state side as well. And both sides have to feel comfortable that their legitimate interests are going to be protected. And I think for states, there is a link here between transparency and democracy. And open societies, and some of that's, of course, always under challenge in some places, and we have some challenges that we see right now around the world. But nonetheless, I think there's still, we've evolved from a system that was presumptively confidential, and we're trying to move to one that's presumptively more open. And I think it's through experience, people need to understand that this even though they may not at first blush like having something out there in an award or another decision or submission, it may enhance the credibility of the whole system in the long term.
We still don't have a question. So
oh my God, have I said anything that's provocative?
If people get sick of my questions, please do jump in, because looking at the participant list, I see that we have some really fantastic experts on the line. In fact, Jeffrey, whom you mentioned earlier in the talk, is listening in right now. So the
Not
one
to call anyone out, yes.
The one question that intrigued me about point 3 in your 6 areas in terms of settlement negotiations and this fear that one might be accused of bribery, not so much the looking weak, but the being accused of bribery. Is there something that could be included in a settlement mechanism, into a mediation mechanism, that could take away some of those concerns, so that what comes out could be presented to a transparency organization? Because I mean, I would assume mediations wouldn't be transparent. no, this is really okay, and you know, we've done the best we could, and this is a good faith settlement, not one of those, you know, money moves from one pocket to the other type settlements.
Yeah, so I've been thinking about this and trying to think about experiences in other areas that could shed light on this. The core idea I've come back to, and the key is how to do it in a way that's really efficient. It is, I think, to get some external validation of some sort. So here's an example. You know, you mentioned at the outset, I do work involving the World Bank and other international financial institutions, and they have their own norms and a sanction system that you know, can be brought to bear when those norms are violated by contractors or consultants. For a long time, they didn't settle cases. Their integrity unit didn't settle any cases. They all went to adjudicative proceedings, which exist within these institutions. But then they decided they could enter into settlements. And the way they do settlements is that you reach an agreement with the unit that investigates and prosecutes, and then it has to be approved by two outside, not outside the bank, but outside this unit sources. One is the first level, an administrative officer in the sanctions proceedings, and the other is the general counsel's office, the legal vice presidency. And they bring to bear, they don't look at the whole thing start to finish. They look at, does this kind of fall within parameters that make sense, and has this applied our rules properly? So they have kind of defined review roles. So I don't know the precise answer here, Freddie, but if you could come up with something like that, it seems to me that could give a lot of comfort to, you know, officials who, you know, are justifiably concerned, given, you know, the public scrutiny of these issues, the public interest in these issues, are justifiably concerned that they could be accused of having been suborned in the process. So, yeah.
We still don't have anyone, so I will keep going.
Well, I was going to say, Freddie, we are just a minute short of.
Well, excellent. Well, I will then. I will.
But I was going to say, we do after you deliver some closing remarks. You know, I was planning on holding the after-hours meeting in about 10 minutes at 5:10. And even if you know, you don't have much to say, it would be great if you could just come and say hi. You know, say hello to Lucinda, and if there are any questions that you'd like to address, then you know, we'll have that forum open for a little while. But like I said, even it would be great if everyone could maybe just come by and say hello, show your face, and that would be nice to see you then.
One of the wonderful things about the JURIS conferences has always been the opportunity to mingle afterwards and to have informal exchanges. And while the after session may not have quite the same benefits of a cocktail, they really are quite fun. And Todd in particular makes sure that there is appropriate levity in the proceedings as well. And gravitas. He's responsible for both because he's one of the few people in the world that can bring both gravitas and levity to the proceedings all at the same time. So then in closing, let me just thank you, Lucinda, for a truly inspiring talk that has showcased what we stand to lose if we take the wrong path down the crossroads, and what we stand to lose if we do not engage in reflection and a responsible dealing in our reform efforts, and to tell us what we stand to gain to the extent that we responsibly reflect on our past and on where, as stewards of processes of international law, where we could lead this process and where we could help not only shape the international economic law regime, but could also have hopefully a positive impact on the international legal order more generally, that is suffering much the same as we are. So thank you so very much. Let me give you a round of applause, because I think we all would want to, but we are just kind of unable to do so. So thank you so much for your keynote.
Thank you. Thank you very much. It's been a pleasure. And again, congratulations on the whole conference. And thank you for your great questions, Freddie. I look forward to the after hours and further discussion of this and other topics.
Great, thank you so much. I'll be sending everyone an email. It is posted in the chat right now. There's a link there, but like I said, as soon as we end, I'll be sending everyone an email with that link, ID, and password, and then we can go ahead and meet there at 5:10 in about 10 minutes. All right, thanks again, everyone.
Thank
Take
you.
care.
Bye-bye.
Bye-bye.